Is Daf Yomi is Bava Basra Daf Kuf Chav Ches Bava Basra 128, but we're going to start on the bottom of 127b, 2 lines from the bottom. Mara has been discussing a dispute between the Rabbana and the Rabbi Yehuda, whether there's an assumption that a certain person was a firstborn child, and the father comes along and says, no, that's not the firstborn. So the Rabbanan said, we don't believe the father to overturn a presumption, a chazaka. Rabbi Yehuda says we believe the father because it says the word Yakir. In this context, the Gemara is going to quote 7 teachings from Rabbi Abba that Rabbi Abba sent to Rabbi Yosef Bar Chama, and one of those teachings relates to that dispute between Rabbi Yehuda and the Rabbanon. So the Gemara says, in today's daf is dedicated for a shmir for the Chayalim, Matzah for the Shuliyim, and a Yeshua for Ham Yisrael. In this eighth Tzara, Shal Rabbi Abba or Rabbi Yosef Bar Chama, Homer Chavero Avdi Ganavta. If somebody says to his friend, "You stole my slave," Omer, no, Ganavti, I didn't steal him. Mativo etzlacha. So he says, if you didn't steal him, what's he doing with you? He says, you sold him to me. Or you gave him to me as a gift. And the person who's has the slave in his possession, we have to assume it was a baby slave, because otherwise we had said earlier that there's no chazaka by movables. That's a separate point. But he says, if you want to take an oath, then you could take it, which he wasn't required to say. The defendant was not required to say that. He did an extra legal claim. He said, yeah, you can go and swear, and then you could take it. Vinishba, it's a dispute amongst commentaries whether it's enough for him to say it, and then he can't retract, but most read it as vinishba. If the plaintiff took the oath, once he went down that road and took the oath, then eno yachol achzor. Then at that point, the defendant can't say, "Oh, I wasn't required to let you do that. I changed my mind." Once he says that, he can't go back. So the Gemara says. So that's the teaching of Rabbi Abba that he sent. So the Gemara says, "My kamashwan, why is he even teaching us this? This is obvious. Tanina, didn't we learn this as a Mishnah in Sanhedrin? If he says, if there are 2 people who are going to court and one of them says, Amro nemen or nemen my father, your father is believed to be the judge, meaning even though they're typically disqualified as judges, I'm going to believe them. Or he says, nemen or 3 cattlemen who are presumably not learned men, they're believed to be the judges. Once he says that, you can't go back. And so we're saying that he can't go back. So why does Rabbi Abba have to say also in this case you can't go back? The Gemara says, no, Rabbi Abba's teaching that even though the circumstances are different, and as Rashbam reminds us, there's a dispute there. Is the in the Gemara whether or not that dispute between Meir and the Chachamim is in a case where he waives his right and says, "I'm going to waive my claim," or even I'll give it to you. So you do this and I'll give it to you. Even then, can he not go back? So Rabbi Abba is teaching us that even in a case where he says, "I'll give it to you," he can't go back. And the halacha is like the Chachamim who say he can't go back, even in a case where he says, "I'll give it to you." So the Gemara says, Shalchei Rabbi Abba, second ruling of the 7 that Rabbi Abba sent to Rabbi Yosef Bar Chama. Halacha govim min havadim. The law is that if there's an estate and somebody has a claim from an estate, normally you can only make a claim against property, not against movables. What's the category? What category are slaves? And so he says slaves are considered something that's like property. You could collect the debt from them. Rav Nachman Amar Ein Govin. Slaves are considered like movables and you can't collect from them. The third case, Shalchei Rabbi Abba or Rabbi Yosef Bar Chama, halacha shlishi b'sheni kasher. So what's a shlishi b'sheni? So a rishon, first and first is 2 brothers. They can't testify against each other, disqualified because they're relatives. Sheni b'sheni is to the next generation down. So it's 2 first cousins. They also can't testify. A sheni b'shlishi excuse me, is a first cousin once removed. So he sent a message that the first cousin once removed is a kosher witness. And Rava says, Af Barishon. He says, not only can a first cousin once removed testify against Shani, not only can testify against first cousin once removed, he can even testify against a Rishon. means say first cousin twice removed, which is actually closer because he's closer to the source. It's his grandfather's brother, his great uncle. He's even kosher to testify about that. Mar bar Avashi, Achshar ba'Abba da'Abba. He even allowed uh, uh, um, a person to testify about his grandfather. And the halacha is not like Mar Baravachi. The halacha is that you're not allowed to testify against your grandfather. So, and the Rashbam explains, he says it beautifully in the Rashbam, as always, the B'nai Banim, U'B'nai Banim ad elaf doros, lo ya'idu avosam. For up until 1,000 generations, uh, grandchildren cannot testify against their grandparents, meaning to say even 1,000 generations below. The Ben, because the son is Yerach Avifu. He's the offspring, the limb of his father. And so that's what the Rashbam says. B'nai Banim u'B'nai B'nai Banim ad elef doros. Even up until 1,000 generations, we pass and you can't testify. So the Gemara then says, the next case, Shalchlei Rabbi Abu Rabbi Yosef Bar Chama Hayu Yodelo Be'edus Karka Achol Nistama. Let's say he knew that he knew testimony when he still had sight. Benistama, and then Rahman al-Atzlani lost his sight. Apostle. So now, even though he had seen it with his sight, and now he can't see it, he's disqualified as a witness. Shmuel Amar Kosher. Shmuel says no, he could testify. Why? After the Mechavin Matzarna, because he couldn't describe exactly how the borders were of a glima, but if it was about a coat, well, then he can't testify. Rav Sheshes, who ironically was blind, said afilu glima, even about a coat, after the mekavin, he could testify if he had seen it, because he could describe midas arko, midas rachel. He could describe its length and its width. Of a naskalo, but if it's just like a piece of silver or gold, that he can't testify about if he can no longer see. Whereas Rav Papa says, afilu naska, if he had been able to see, and even though now he can't see, afshar, he can testify the makave midas mishkolotzav. He could talk about its weights. And so the Gemara challenges these final three positions to say he could testify even though he can't see right now. Meisvei, we learned in the Brisa and Erchin. Now, let's say a man knew testimony before he became related to his father, and why by marrying his daughter, and he became his son-in-law, or if he was sound mind and then he became a deaf mute, or he had sight and became blind, that he was sane and he became insane. In all these cases, possible he's disqualified. If he knew the testimony and then it became a disqualified witness, he's disqualified. But let's say he knew the evidence, then he became the son-in-law, then the man's wife died, so he's back to being a kosher witness. Or same thing in all these cases. He was kosher, then became non-kosher, and then became kosher again, either sound mind again, or he had sight, they became blind, he had sight again. He was sane, he became insane, he became insane again. Kosher, in all those cases, is kosher. And zaklau, and the rule is kosher tchilaso or sofo v'pasos, basal. Anything where at the beginning, at the end, if in either the beginning or the end is in a state of disqualified, is disqualified. But tchilaso v'sofo v'kashrus, kosher, but if it's beginning and the end and is kosher, he's kosher. So this is a dispute, a contradiction to the final three Amoraim, who say in all these cases to Rav Papa, to Rav Sheshes, and to hold on one second, to Rav Sheshes, Rav Papa, and Shmuel, because we see in all these cases, he needs to be kosher when a testimony is being given. And so the Gemara says, tiyufta the kula tiyufta. Indeed, it's a dispute to all these three Amoraim, aside from Rabbi Abba, for whom we say, the is like, because he says that you become disqualified even though you had sight at the beginning. Next case, Shalach Rabbi Abba, Rabbi Yosef Bar Chama. Hold on one second, excuse me, let me get a teacher. Next case on the top of Kuf Chaf Ches Amud Beis Shach Rabbi Abba Rabbi Yossi Bar Chama. So he says, if a person says Omer al Tinok ben Abanim, so this is how we're going to get relevant to why we're bringing up this discussion. If a person says about a child amongst the children, and he says something, we don't know what he says, then we're going to believe him. Neman Rabbi Yochanan Amar Eno Neman. Excuse me, Rabbi Yochanan says in that case he's not believed. So the Gemara says Maika Amar. What in fact is he saying? So Amar Abaye, Hachik Amar Abaye says this is in fact what he's saying. Omer al Tinok bein Abanim. If a person says about a child amongst all the children, Yirash kol nechasai. If a person says about a child amongst all the children, let him inherit all my assets. If a person says about a child amongst all the children, let him inherit all my assets, he's believed. Rabbi Yochanan ben Broka. And this is the position of Rabbi Yochanan ben Broka that we're going to get to. He says that a person is believed, is allowed to say, and I foreshadowed the Gemara's answer. A person is allowed to say that one person can inherit all of my estate as long as he was one of the kosher heirs, meaning he can give it to one brother above all the other brothers, and that's what Rabbi Yochanan says. That's what Abaye says that this is what this is referring to. So the Gemara says that's what Abaye says. Rabbi Yochanan says Eino Naman Kirabanan. Rabbi Yochanan says no, he's not believed to say that like the Rabbanan. The Gemara challenges Abaye's explanation. Maskefo Rava. Rava challenges, how could you say that? Hi Nema Meino Neman. Yirash will Yirash be my way. Why does it say believed or not believed? That's not the proper language. It should say he can inherit or not inherit, whether we pass like Rabbi Yochanan and Broka or not. Not that he's believed or not believed. Of course he's believed. The question is, he's believed to say, I want this one to inherit. The question is he correct? So therefore Rava gives a different answer. So Rabbi Abba is pasking like Rabbi Yehuda. That's what Rava says. He says that this child is the firstborn, and then he's believed like Rabbi Yehuda. But Rabbi Yochanan says Eino Neman. He's not believed Kirabanan, like the Rabbanan who say he's not believed. Shalchei Rabbi Abba or Rabbi Yosef Bar Chama. So Rabbi Abba sent a message to Rabbi Yosef Bar Chama. Omer Tito Ishti. So this is the next halach. He says, I want my wife to inherit like amongst all of the other children. Basically, he wants her to take a portion of my inheritance like amongst all the other children. And then his words are going to be valid. And she's able to take. Meaning to say the wife is waiving her rights to the ksuva. That's one of the explanations of the Rashbam. The Rashbam gives a second explanation that this is in addition to the ksuva. But he's saying, I want her to inherit like one of the children. She takes like one of the sons. But that's only, says Rava, two caveats. That's only what he has now, because he can't give what's not yet in existence. So only what the estate has now, that he could give her. And in addition to that, and she'll also have to split it with the children who are born after the fact. He didn't mean to exclude those from the division that she's getting. Now we have a next case, and this is the seventh ruling. Shalach le Rabbi Abba or Rabbi Abba or Rabbi Yosef Bar Chama Motzi Shtarchov al Chavero. Let's say somebody produces a note on his friend. The lender produces a note. Malva Omer lo nefreiti kum. The lender says, you never gave me anything. The Lova Omer, and the borrower says, Parati Mechza. The borrower says, I paid half, which is a classic case of what's called Modeh B'Miktzas, a partial admission, which he'd have to take an oath about. Va'edim me'idin sheparakuo. And the witnesses testify that he's paid everything. Witnesses come after the borrower testify they paid half, and they say actually he paid everything. So we're going to say under those circumstances, Harei Ze Nishba, that the Rashbam says the borrower takes the oath, Vigova Mechza Minachasim Minechorim. So the borrower takes the oath and says, I paid half, and he only has to pay the other half. But the lender can only collect this from free and clear property because there's no lien on the property because there's no contract, because the contract that the witnesses said the whole note was paid, so you can only collect it from free and clear property. But not from a lien property. Because we say we're relying on those witnesses who said it was all paid. Even according to Rabbi Akiva, who we saw this sugya in Bava Basra, in a case where a borrower admits to a partial amount, and he has proof from the contract that he actually owes less than what he admitted, we say Meishav Aveda Havi. Rabbi Akiva says that it's like he's returning a lost object, and who's returning a lost object because he's admitting about something that there's no proof that he's liable, and he could have said he's not liable for anything, and so therefore Rabbi Akiva would say he's exempt from an oath, even though Rabbi Akiva would say in a case where you admit to something where the contract says you owe less than that. That's the case. Rabbi Akiva's case was where there was no witnesses. That's what Rabbi Akiva's case was referring to, because he says, Rabbi Akiva's case, if you remember from Mametzia Davdala, we're talking about a case where the contract says Sulayim Dinarim, and the witnesses don't know anything more than the contract, and so therefore it means two, and so therefore the contract is helping him. But if there are witnesses that he saw there, he doesn't know what they're going to testify about. Here too say irtas. He's afraid. He's afraid that maybe the witnesses will help the lender, and so then he's going to testify, and they'll testify they didn't pay anything. And so therefore, when he does a partial admission, it's not like a Meishav Aveda, so he has to take an oath there. So Maskef or Marbar Avashi, Adarab, he says just the opposite. Adarab, just the opposite. Just to let me just go over this case again, because we said it quickly. The case from Bava Basra refers to a case where there is a loan document, and in this loan document it says that person moving, let's say, borrowed from Shimon Slayim Dinarim, these two separate types of coin. It doesn't say the amount, and the lender says he borrowed 5, and the borrower says he borrowed 3. So Rabbi Shimon Eliezer says, since it's a partial admission, he has to take an oath. Rabbi Akiva says no. He's like a Meishav Aveda. He's exempt because Rashi explains, because the borrower could have said that he borrowed 2. And so therefore the contract is helping him, because the contract says that he's only liable for 2. And so since the borrower on himself said 3, he's like returning lost object, and he doesn't have to take an oath. And so he just gives him what he gives him, and he's exempt from the oath. But the Gemara says, but even here, according to Rabbi Akiva, he would have to take an oath, because here there are witnesses, and he doesn't know what the witnesses are going to say. And so therefore, he's afraid, and so therefore, that's why he makes a partial admission. So the Gemara says that Marbar Vashi asks, I feel Rabbi Shimon ben Eliezer. Even according to Rabbi Shimon ben Eliezer, he says in that case you have to take an oath. In the case where he admits to 3 and the lender wants 5, and then there's a contract that implies 2. Why does Rabbi Shimon ben Eliezer say you have to take an oath? He has no witnesses to help him. But here he has witnesses. So for sure he's like a Meishav Aveda. And so therefore, since the witnesses are going to say he has nothing, of course he shouldn't have to take an oath at all. And now like Rabbi Abba, who says that he has to take an oath like every partial admission. Gemara says, Darash Marzutra Mishmenu Rav Shimon Barashi, Hilchasa B'Kol Hanishmaita, Kiddushach Rabbi Abba Rav Yosef Bar Chama. It says the loch in all these cases is exactly like Rabbi Abba's center of Yosef Bar Chama. Amar Le Ravino Rav Ashi to Rav Nachman Mai. And what about the case where he argues with Rav Nachman, where Rabbi Abba said you could collect from the slaves as though they're real estate, and Rav Nachman says you can't. So he says, okay. And normally we would say that Locha is like Rav Nachman. Rav Nachman was the Av Bezdin. So the Gemara says, no. Rav Ashi says to Ravina, Amarle, no, we changed what we got. We changed the text. Amarle, ain't golden must don't say that Rabbi Abba says you could collect, say you can collect. And then say, V'chein Amar Rav Nachman. Indeed, that's what Rav Nachman said. We're going to go on now, but this is the end of the daf, so I'll stop the recording and we'll go on. So the Gemara says,